What the NAIC has done, and again, the NAIC is the National Association of Insurance Commissioners. It's the national association to which all the state insurance regulators belong. They get together at the NAIC to develop policies, to develop best practices, to develop model laws and acts on every insurance issue that you can imagine. So last year what they did was they created a cybersecurity task force. The NAIC has task forces and working groups and committees that deal with all various insurance issues. So now they've created one specific to cybersecurity. It's actually almost a committee of the whole. I think there are probably 35 or 40 regulators who belong to this task force from 35 or 40 different states, I should say. And essentially, the goal of the task force is to be its sort of central repository for dealing with cyber issues. So they're not only going to monitor developments in cybersecurity and make recommendations to the regulators in terms of what they should do, what the regulators should do. They're going to work with all of the NAIC committees to deal with cyber issues as they come up, whether it's P&C, life, market conduct, financial regulation, and so forth. And they're also going to develop model regulations, model rules, which is probably the most important issue for us. They have already adopted what they're calling a roadmap for cybersecurity consumer protections, which they adopted at the end of last year. They initially called it a cybersecurity bill of rights. We in the industry we're quite concerned actually about calling it a bill of rights, because calling something a bill of rights makes people think that they actually have rights. And this document that was put together by the NAIC was basically a collection of maybe good ideas, maybe some were not so good, but good ideas, perhaps best practices and those sorts of things. But they certainly were not legal rights that consumers had in every state. And so they changed the name of the document to the Roadmap for Cybersecurity Consumer Protections, and they actually intend to use it as a roadmap. The document essentially talks about issues like what to do in case of a breach, what kind of information consumers are entitled to receive or should expect to receive in terms of notices when there's a breach, what the timing should be, and issues like that. And so what the regulators are going to do is take that roadmap, and their intent is to develop a model statute that then will push out to the states for enactment. As part of this process, what they're doing is they're looking at 4 of their old privacy models that are in place right now. They're listed on your screen here: the Insurance Information and Privacy Protection Model Act, the Privacy of Consumer Financial Health Information Regulation, the Standards for Safeguarding Consumer Information Model Regulation, and the Insurance Fraud Prevention Model Act. These models were all put in place. I guess the oldest one is from 1992, and the other 3 are from the early 2000s. And they were put in place to deal with privacy issues, so with information and the protection of information. But they really were so long ago, and they're so dated now, that they don't deal with sort of the cyber kind of focus that we're concerned about in 2016. So the NAIC is going to look at those models and update them, and then they may or may not create a single model dealing just with cyber issues. There's some debate as to whether they should do one model, whether they should do the 4 models, or exactly how it's going to happen. But nonetheless, we are going to see within the next year or so some changes in terms of what the states, some updates in terms of what the states are expecting with respect to the protection of cyber information, probably of all protected information, and then breach notification as well. The models that are in place right now dealing with protection of information are really most of what the insurance sector is required to comply with respect to data security right now. So these are the bills that you guys and the carriers out there are really needing to focus on, along with some federal legislation like HIPAA privacy rules and things like that. But these are the insurance-specific, state insurance-specific requirements that are in place. And they're not in place in all the states, although I would say that some of these, for example, the privacy of consumer health and information model regulation are in place in a majority, half the states, maybe 25 to 40 of the states. So they're in place, and you guys are complying with them right now. One of the issues that we're working with our fellow trade associations on, the other insurance trade associations right now, is to try and figure out if there's a better or different approach that the NAIC and the state regulators might take to these issues, as opposed to either drafting a new model that touches on everything or opening up all these 4 separate models, just to try to figure out how best to approach the issue from a global perspective. And one of our concerns is this, that is, once the NAIC takes action, then these models all move to the states. And what our hope is that whatever rules and requirements are put into place, they're as uniform as possible, so that we're not having to do something different in New York and California and Florida and Idaho and South Carolina. So we're working at the council. We're working with a number of our fellow insurance trade associations to try and decipher this at this point. I don't know if the industry will be able to get all on the same page on this. We've got different interests, particularly the producers sometimes have different interests from the carriers on these issues, and even carriers one from the other depending on the line of insurance that they cover and so forth. So we're really working on this a lot right now, and frankly would love to get your feedback as this process goes on. So if there's anyone out there who's interested in sort of looking at the industry's response and what we're trying to do with the states and the NAIC at this point, please do let me know. My information will be at the end of the webinar. So that's where the states are right now. So there's not immediate action in terms of cybersecurity. The NAIC hasn't done anything yet in terms of an acting model, but they will be, and it'll be a busy year on that stuff. Now to the state data breach notification. This is an area where 47 states have taken action in terms of data breach notification requirements. So what happens, what do you need to do when your information has been compromised? These are not insurance-specific laws. So unlike the NAIC privacy models, which are really data protection models and insurance-specific, these data breach notification requirements that I'm going to be talking about now are not insurance-specific. They apply to everyone. So as I said, 47 states have enacted them. Generally, these laws require entities to notify individuals when the individual sensitive information has been breached. There's only 3 states that don't have these laws: Alabama, New Mexico, and South Dakota. Essentially, as I said, what happens is that if your sensitive information has been breached, then the company that holds that information has to notify you in some way. Sensitive information, just so you know, so we're all on the same page here, is called different things in different states. Some places it's called personal information, some states it's called private information, other states it's called sensitive or non-public personal information, that sort of thing. But generally it's some combination of name, social security number, address, driver's license number, account numbers, credit card numbers, things like that. And most of the states say that if it's publicly available information, then that information is not sensitive or protected. But other information that is not publicly available, that includes the combination of those items I've listed above, are going to be protected. So what are the components of a state data breach law? There's 4 components essentially. First, so if it's sensitive information, we have to determine who is the obligated entity. So who is required to notify the consumer if data has been breached? Second is the timeline. When is the entity required to notify the consumers whose information has been breached? Third is the method. How, in what format is the notification permitted to be made or required to be made? And finally is the content. What do you have to say in the notification to the consumers? So put a little meat on those bones. First, who's required to notify? Generally, any entity holding sensitive data has an obligation to notify consumers if it's been breached. So an entity that has the data, if you're holding information on your computer systems or wherever, and you're breached, you're going to have an obligation to notify. The responsibilities vary from state to state and sort of depend on, or can depend on, where the entity falls in the chain of data possession. So there could be a difference between ownership of data, so the entity that actually owns the data and the entity that may be transmitting the data from the consumer to the carrier, for instance. It could be different if it is information that a producer, that an insurance agent holds about its own customers, its own clients, as opposed to information that it holds for a carrier. But in either case, it's more than likely that if the insurance agent's system that has been breached, that information, there's going to be some obligation on the part of the insurance agent to notify the customer, perhaps the carrier, perhaps both, in terms of what's going on. But this is a really important step in the process to determine who or where that obligation, who has the obligation to notify. Second, when do you have to notify? The states are kind of, I guess I wouldn't say all over the board, but almost all over the board on this. And there are few states that have specific timelines. As you can see over in the right-hand column, there's there's about 7 states that have specific time limits in terms of when the notification needs to go out to consumers and that their data has been breached. And those range from 45 days for 5 of those states, up to 90 days in Connecticut. But most of the states have more wishy-washy language. Like over in the left-hand column, the most expeditious time possible without unreasonable delay, in an expedient manner without unreasonable delay, that sort of thing. And then as soon as reasonably practical or as quickly as possible, the standard, which is over towards the right there. So there are different ways that the states approach this. We actually have a map I'll show you, which sort of gives us a little bit of a pictorial in terms of how a company that needs to comply in multiple states or maybe all the states is going to need to look at this to determine once a breach happens, what the time frame is in which it needs to respond and notify consumers. And one of the issues here is to determine, when we're talking about, without unreasonable delay, that sort of thing, how do you determine unreasonable delay? And what happens if you need to notify, and in some cases you will need to notify law enforcement, you'll need to notify the regulators, they may want to do an investigation before it becomes public and that sort of thing. And so folks really do need to be aware and sort of cognizant of what these requirements are in terms of the timing of notice, but then also what the rationale or what the basis can be for not sending the notice out right away in case there are other regulatory or law enforcement reasons not to do so. Third, what's the method for notification? Really, mostly it's written or electronic notice, but I guess a majority or more of the states also allow telephonic notice. So it's pretty straightforward, your basic, I think, email, letters, telephone, that sort of thing. There's a couple of states, Indiana and Wisconsin, that are a little idiosyncratic. Indiana, for example, allows for faxes. Wisconsin allows for a method that an entity has used previously to communicate with the person. So there's a little wiggle room there in Wisconsin. But really, I think the basics are in writing, by mail, by telephone, or electronic notice. Finally, what's the content of the notice? The content varies by state. It gets very specific, very detailed, but I think that there's basic sort of common elements, and that's, the name and contact information of the breached entity, a description of the breached information, the date or estimated date of the breach, a general description of the breach, what happened, and a contact number for the credit reporting agencies. So you need to inform the consumer that, you got your credit reporting agencies information so that they can get in touch with them and tell them so they know what's going on and protect their credit. And then generally a reminder to remain vigilant, for instance, of fraud and identity theft. Because they've been breached, they're more susceptible or perhaps in more danger of getting ID theft going forward. And that is really the content. So those are really the elements of the notification, the breach notification requirements. We have on the STEPTO website a data breach or a cyber toolkit, essentially, with a great deal of information, both about all the state laws in terms of data breach notification, with specifics in terms of what you need to do, also links to those laws, and I would recommend that anyone that, suffers from a breach would want to contact their counsel, would want to, make sure they know the details of all these states. It's easy to go through and generalize about these things, and I think the information on the website provides great information, but really when you're in the thick of it, you really want to know the details of it and exactly what you need to do. So it's important to do that. At any rate, the STEPTO website provides a great deal of information. This is all publicly available, so please feel free to click on the link there, and I think you'll find a lot of very helpful information. And we would be happy to answer any questions. I'm going to see if there are any down here on my screen. I don't see any questions right now, but I'm available. There's my email. Ava Rigamonti at STEPTO is also available. We do a lot of work on this stuff, as you know, and we're happy to answer any questions or help in any way. And with that, I think I will turn it back over to Amy.
Thanks, John. I think that's all we have for today. Barring any questions, feel free to email those guys, and thank you all for tuning in. Have a good day.